We mentioned earlier in the show that the Supreme Court heard arguments Monday in a case that will likely shape the future of free speech online. At issue, whether social media sites like Facebook and YouTube are like newspapers deciding what to publish, or whether they're more like utilities required to carry every message that comes through the wires. That very question could have nationwide implications, worldwide implications even. For more, I'm joined by Jimmy Hoover. He covers the Supreme Court for the National Law Journal. So, Jimmy, let's start just with the key tensions that the court is being asked to resolve.
Sure. Well, the states argue that these laws prohibit what they call censorship, and that the newfound power of these social media companies with their millions of users should have to basically, like common carriers, as you mentioned, take all comers and not discriminate against people based on their viewpoint. But obviously, the internet companies themselves say that the governments of Florida and Texas, can't compel what are private companies to host speech that they disagree with, that goes against their First Amendment rights.
And so when you say common carriers, you're talking about the utilities. So the states have the views that social media platforms are like utilities. The companies themselves say, no, we're like newspapers. We get to pick and choose what we can have. Is there any interesting or anything interesting in the difference between the Florida and the Texas laws?
The Florida law is slightly broader, which kind of gave a little bit of a procedural quirk to the arguments. And there was some suggestion by some of the justices today during oral arguments that maybe some contexts for the Florida law might not be unconstitutional, which could have repercussions down the road for whether the Supreme Court decides to let it take effect. But what you heard today was a general skepticism by a number of the justices on the court of the constitutionality of, as I mentioned, the governments of Florida and Texas telling these private companies what they can and cannot host on their platforms.
So the court is basically, based on your reading of their questioning, sounds like they might be inclined to come down on the side of social media platforms are newspapers, not utilities.
Yeah, it was a really tricky read. It was almost 4 hours of oral arguments, and you heard questions from all over. And this one was kind of one that defied the usual liberal conservative split. I found it kind of interesting that Biden's new appointee to the court, Justice Ketanji Brown Jackson, was among the more sympathetic to the states of Florida and Texas's position here. But certainly you saw a skepticism by a sizable block of the court about the constitutionality of this type of new law. This is really new territory here for the court and for the country for regulations like these aimed at these giant tech behemoths.
So as the final last question, that interests you because Florida and Texas tend to be conservative states. They want to have social media, allow everything because they feel like social media companies are tamping down on conservatives. So for Ketanji Brown Jackson to be seemingly on their side is the interesting point. So what was her sympathetic view to allowing states to do that?
She kind of reflected the arguments that the Solicitor General from Florida, Florida's top lawyer to the Supreme Court, was making, which is that this is the modern public square. That was one question that she posed to one of the lawyers in the case. And should we really be allowing private companies to exercise this amount of control that we wouldn't from the government? And there was also the idea that, potentially some aspects of at least Florida's law might actually be constitutional. So should we just strike down the whole thing, even though pieces of it, let's say Gmail, for example, should be basically forced to be a common carrier? So you heard a wide variety of oral arguments. It's hard to predict what the court's going to do, but we should be getting a ruling by the end of June.
Jimmy Hoover with the National Law Journal. Thank you so much.